For this session, each speaker will give a 15 to 17 minute speech, followed by a Q&A session. The moderator for this session is Professor Tong Zhiwei. So without further ado, I shall pass the stage to Professor Tong. Let's give him.
好的，这个我非常荣幸，今天下午跟一位女士和一位先生一起展开这个下午的讲座。我先介绍一下我右边的这一位女士是娜塔莉，李钦斯对应，这个是原来在世界银行做律师做了30多年这是对中国事务、法律事务特别熟悉。 现在又在这个霍普金斯大学做兼职的教授，那么呢，是我们今天是我们我们娜塔莉首先发言然后呢，还有一位是我们中国著名的法学家，这个北京大学的霍伟芳教授，这个很多人都知道的，你看看都开始开巴掌了这个我今天的这个举词是严格的按照举办方的要求来的所以第一个发言，我们首先欢迎这个娜塔莉·李钦斯特因女士开讲。Please.
Thank you very much. I think this is in the tradition of rock music concerts where the main performers come later and some of us are the warm-up act. So I'm happy to be on the panel with these rock stars. I'm also delighted to be at LSE. I know from my years in the World Bank that this is a very important institution for economists. But I was very struck when I arrived yesterday because actually you're next to Lincoln's Inn Fields. And for an American-trained lawyer such as myself, this is really the pinnacle. But it is an interesting reminder to me about the differences in legal systems and also about legal transplants. People talk a lot in Chinese law about different legal systems being transplanted into China. But of course, my own experience suggests that the transplants have a long history, and maybe the United States has a transplanted legal system, or many legal systems. So one of the reasons I wanted to speak first is because I think you have to look at each country's legal system in its own cultural, economic, social, and political realm, as well as looking at what it produces in terms of justice for the society. So there are two themes today, I think, for the conference. Overall theme is rebalancing China. And I think as part of rebalancing China, the legal reforms are actually quite prominently recognized as part of the third plenum and other recent decisions. Indeed, democracy and law is listed as the second subgroup under the reform leading group that had its first meeting in January. And both the head of the Supreme People's Court and the head of the Supreme People's Procuratorate were listed in the 23-person group. Now, I realize that there may be a stroke order issue about being listed second. I'm not sure whether that was priority or grammar. But there are very important legal reforms. At the same time, there are a number of contentious cases, and those will be discussed, I think, a little later in the discussion. So I want to start by giving you a little background of my perspective on China's legal development over the last 35 years. I don't think you can talk about rebalancing unless you talk about where things are to start with. And here I'd like to talk about three dimensions of development since 1978: the legal framework, legal institutions, and legal consciousness. Before I do that, I think I also have to mention the very different legal history in China. And law in China does have a very long history, with codes going back to the Tang Dynasty, as well as informal commercial rules and a religious element. And it's a very different history from that of the United States or Britain or many other countries. So when you look at China's legal development, I think you have to bear the different nature of law in mind. In fact, law as a political and administrative tool to maintain social order and stability probably sounds quite familiar to anybody in today's China, but many people would argue that that was the role of law in China for 2,000 years. So let's look briefly at the legal framework and the changes that have been made in the last 35 years. I think you can sum this up if you look at a quote from a previous third plenum in December of 1978, where Deng Xiaoping was famously to have said, "There must be laws for people to follow. These laws must be observed, their enforcement must be strict, and lawbreakers must be dealt with." Because if you start with no law, in a sense, and with the violations of laws that took place in the 10 years prior to 1978, or 12 years, you start with a need for reform and opening up and for developing a legal framework. If you fast forward to 2 years ago, the National People's Congress Standing Committee, in its work report, announced that the socialist legal system with Chinese characteristics had essentially been achieved by the end of 2010. This was a goal set in 1997. So in terms of the legal framework, I think you can say that there is a comprehensive legal system in terms of the framework. It is not complete or perfect, but many areas of law that were not addressed before are there. The Constitution is a very important part of that framework, but in the presence of some great constitutional scholars on the panel, I will not talk about the Constitution at any length. I think one can find changes in civil law, in economic law, in the criminal law. I think there are differences when you look over the 3 decades and you see that the relationship between the law and the legal philosophy and economic reform is quite deeply intertwined. So if you look at the beginning of some areas of law, for example, you see different laws based on ownership, very particularized. So ownership makes a big difference, whether you're a state enterprise, a state-owned enterprise, a collectively owned enterprise, a private enterprise, where you have different tax laws. So part of the changes has been to unify and to have the same legal rules applying to different entities regardless of their ownership structure. If you think about the change in ownership structure that's taken place in China over the last 30 years, you can see where changing the legal system was necessary to promote economic reform. For the future, I think in terms of the legal framework, it's very important to keep adapting, as it is in any legal system. Nothing is static. So even though I think there's a basic system of law, obviously first implementation is very important, which is what we'll talk about next, but also keeping it current. And one of the problems is if you don't change the law, you create other problems. So for example, there is a mechanism in China, as most of you know, called Xinfang petitioning, which is, there are, I think, as many Xinfang cases a year about as court cases. I was recently asked by a foreign organization, did I think it would be good to help China with the petitioning system to make it a better system? My reaction was, it would be far better to fix the underlying problems than to fix the petitioning system, which, by the way, I'm not sure there's so much that foreign organizations can do to help a very peculiarly Chinese mechanism. But if, for example, you thought that 50% of the petitioning cases were about land takings, you could probably fix petitioning by fixing the land system. Now, maybe it's easier to play with petitioning than to fix the land takings problem, but that's really the underlying problem, and that's where you would need the legislation, I think, to move things forward. Another, I think, very striking dimension of China's legal reform has been the change in legal institutions. So here, if I were looking from a foreign lawyer's point of view, first I would look for the legislature. So the National People's Congress has certainly developed into a more robust body than it was in the earlier years. There's been an enormous amount of legislation. Any article you find will have exactly the numbers because that's very important. But I think it's the professionalization of the NPC, somewhat greater openness, and activist committees that's been very interesting as you see this institution developing. But there are a lot of challenges. One of the challenges for the NPC and for the other Chinese legal institutions is the inconsistency between laws at different levels or at the same level and regulations. You could have improved that through improving legislative review both before drafting and after drafting to look for conflicts. You could also improve that by having a constitutional review process. There is also a challenge, I think, for the NPC in the drafting process where not just the quality of the drafting, but you see bureaucratic rivalries that really are reflected in the kind of legislation you can get. I live in Washington, D.C., so I think bureaucratic rivalries are a way of life. But it's very interesting to see that counterparts in China struggle with the same problems between different ministries and the relative power within the hierarchy of ministries. But when you see this reflected in suboptimal legal provisions, then you think it's a problem that needs to be fixed. Another legal institution, I would say, is the State Council and the local people's governments. And here there's a whole world of administrative law that I think has changed dramatically over the last 35 years. Part of the change to the market economy has been to change the fundamental role between the citizen and the state. And administrative law, being able to challenge the regulatory decisions made at the local level and at higher levels, is a really important part of that. But that's a real challenge. And the number of cases that are actually accepted by courts on administrative cases has really not grown very much. I think it was 120,000 for a long time. Maybe now it's 135,000. So not a rapid growth in cases, but an area that really needs to grow to go with the market reforms. The people's courts I will talk about in a little while. But for the future, I just want to say that I think a very important piece of the institutional framework is public participation. And I think public participation is important from two perspectives, especially for legislative drafting. When I had the opportunity in the World Bank to help with legislative drafting in the 90s and the early 2000s, we used to think that it was like legislating into the dark. You could look at how the bankruptcy laws were drafted in any other country you wanted to. You could look at how the banking law, the central banking law, but you couldn't predict what China's socialist market economy would look like. So very hard to design a law. Now you have a Chinese reality that continues to develop like everywhere else. So you should get as much input from as many different parts of that society and economy in advance so you can improve and have a draft provision that has the result you want it to have from a legislative point of view. The other obvious reason for public participation is to give people a feeling and maybe the reality that they are participating in the process of legislation. And there is quite a bit going on in terms of soliciting public comment, but I think getting comments from 192,000 individuals on the second round of a draft law is open, but maybe not as useful as maybe more targeted public participation. So that's all I'm going to say about legal institutions. The last piece I think that is perhaps the most important is legal consciousness. Popular attitudes towards law have changed dramatically, I think, in the last 35 years. And while traditional ideologies persist, I think in many cases with prosperity, people have something to protect. If you look at dispute resolution trends, the number of cases, litigation cases that are accepted and are actually go through the court system, the numbers are quite high. The numbers for mediation are high, but there's also been a big push to mediate instead of adjudicate. So that isn't necessarily an indication that there's more. It's just going into a different place. Petitioning, as I mentioned, is about as popular, if you want to look at it that way, as court cases. So clearly people believe that the law matters to their lives in some way because they're going to try to use the law to resolve disputes. And I think part of this is demographic and economic impacts. So in my mind, if you think about dispute resolution in a rural village 20 years ago, or in a state enterprise before reform, or in an urban neighborhood, and then you think about an urban high-rise, where the parties don't necessarily know each other, where there isn't a family or a village hierarchy, you start to see where, you know, when the plumbing breaks and you have a dispute, people are going to need to turn more and more, I think, to the legal system. So I see that as changing people's consciousness. I think, obviously, the economic changes and the needs that have been discussed in other panels for a market across China also gives the need gives a different legal consciousness. If I have time, I just want to say 1 minute.
2 minutes to go.
Okay, so I do want to talk about the courts, and I will only say a little bit here, but I think this is a really interesting juncture after the third plenum and after a number of other pronouncements about wrongful convictions and from the Supreme People's Court. I think for the Chinese court system, there is an interesting future of judicial reform. Judicial reform's been going on in at differing speeds, let's put it that way, since 1999. Let me just address one piece of that, and that is independence. So the Constitution says people's courts shall exercise judicial power independently. But if you look from the bottom up, you have all these potential interferences. You have the party, in particular through the Political Legal Committee. You have the local People's Congress, which appoints and removes some of the heads of the courts and also is supposed to stay out of individual cases. You have the local people's government, which has a financial and a budgetary role. You have the higher court and its relationship with the lower court and non-transparent instructions. You have the senior leaders in the court, as well as the adjudication committee. You have outside influences from the media and the social media, and you have an issue about corruption. When I read the third plenum decision and these other decisions, I see that there is a potential reform for every one of those levels. So I don't think that's going to happen overnight, but I think if you start from saying the Political Legal Committee shouldn't interfere in individual cases except those that relate to foreigners and national security, if you separate the administration of the courts from the local people's governments, even if it's just within the province, if you get rid of eventually the adjudication committee, if you say that the court has to make the decision in the courtroom and not outside of the courtroom, I think all of those are really important. And if the last thing you will say is the sentence in the third plenum that says, let the popular masses feel fairness and justice in every judicial case. Now we will talk about how they're not there yet.
好，我们感谢叶先生参与律师，还给我们做这么好的这个演。